Good afternoon. We are delighted to welcome you to our Procurement Reform webinar, in which we will look at the current status of procurement reform in the UK. The webinar will focus on the status of the changes which were introduced by the new EU Procurement Directive and implementation into law in both Scotland and England and Wales. The webinar will be recorded and will be available on our Vimeo site. Details of how to access that will be given later. Before we begin, there are a few housekeeping matters to start with. To minimise background noise, I've placed you all on mute, and if you would like to ask questions, please do so using the webinar chat function. In order to keep within the 25 minutes, we'll be answering as many questions as we can at the end of the presentation, rather than as we go along. I am Kate Gillis, a flows Turner Construction and Special Projects team. I specialise in construction and engineering dispute resolution and am based in Edinburgh. I'm joined by my colleague Ewan Murray. Ewan is an associate in our infrastructure team who specialises in infrastructure projects and public procurement. Ewan is based in an Edinburgh office but regularly works from Glasgow and London given the nature of the projects that we work on. Both Ewan and I regularly advise on infrastructure contract issues and also on disputes for a range of projects and clients across the UK.
Thanks, Kate. In terms of the agenda for the webinar, today we're going to look at the current status of procurement reform across the UK, taking a look at the position in Scotland in terms of both implementation of the new EU Procurement Directive and also the status of the Procurement Reform Scotland Act 2014. We'll then go on to take a look at the status of procurement reform in England and Wales, as well as taking a look at some of the more interesting changes that the Public Contracts Regulations 2015 have introduced. Following that, we'll take a quick look at the Fastweb case, which has had an impact on the public sector in particular, as it's moved the goalposts in terms of mitigating the risk of ineffectiveness orders. There will then be a short summary and an opportunity to ask questions before the end of the webinar. So before looking at the position in Scotland and then England and Wales, I thought it would be useful to consider where the new rules come from. The new EU Procurement Directive was approved by the European Parliament on 15th of January 2014 and was published in the Official Journal of the European Union on 28th of March 2014. Member States therefore have 2 years to implement the new directives into national law, and each Member State obviously takes its own approach and timeline for doing so, which means that the regulations will not be enforced in all Member States at the same time, but the timeline should ultimately align at the end of the 2-year period. As you'll see later in the webinar, the constituent parts of the UK have in fact themselves taken a different approach in terms of timescales, which will have implications for the private sector in particular, particularly affecting those that bid for contract opportunities throughout the whole of the UK. Some of the key proposals from within that new EU directive are listed on the slide there, and I'll just run through them quickly as follows. It seeks the introduction of a simpler PQQ bidder credential process, known as the European Single Procurement Document. We'll explore this further slightly later in the seminar, but it's a tool which has the aim of reducing the administrative burden on bidders at PQQ stage and is likely to be welcomed by the market. It also seeks to introduce relaxations around using a negotiated procedure. Historically, the negotiated procedure was replaced by the competitive dialogue procedure and wasn't really used other than exceptional circumstances, but the new EU directive makes provision for a competitive procedure with negotiation. The ability to take into account past poor performance of bidders has also been introduced. One of the things that frustrated many contracting authorities in the past was that it was difficult to evaluate past performance of a bidder to take account of poor performance on previous contracts. This is definitely likely to be a welcome change for the public sector, but perhaps not quite so welcome from a private sector perspective. And we'll explore this further in the context of the Public Contract Regulations 2015 slightly later on. The EU directive also removed the distinction between Part A and Part B services. Previously, contracts that fell into a separate subclass of services known as Part B services weren't covered by the full remit of the procurement regulations. Certain provisions did still apply, but the overall procurement regime for Part B services was lighter than that which applied to Part A services. This has been removed under the new directive so that now all contracts that are above the EU procurement thresholds are subject to the full remit of the EU regulations. There's been a reduction in statutory response times. The new EU directive includes shorter minimum timescales that the previous procurement regulations provided for, and this is intended to speed up procurements with a view to creating greater efficiencies. This will be welcomed by the private sector in particular, who often consider public procurement procedures to be extremely long and inefficient. I'd say it's helpful to some extent. However, procurement functions within contracting authorities are now very good and very experienced at structuring and running competitions, and therefore in terms of timescales there does come a point where it's not possible to reduce timescales beyond a certain amount, as time is obviously required to properly scope the documentation and have useful dialogue or negotiation to ensure properly developed solutions. The new directive seeks to safeguard conflicts of interest. It focuses on it much more than the previous regime did, and that's flowed through into the provisions of the Public Contract Regulations 2015. Importantly, from an SME perspective, the new EU directive requires a cap on turnover requirements that doesn't exceed 2 times contract value. This will definitely be welcomed by the market, as SMEs often felt that high turnover requirements in PQQ documentation blocked their ability to bid for work, which they were in fact perfectly able to do. The new EU directive also introduces the concept of innovation partnerships, which may be useful to contracting authorities looking to procure research and development work or a novel product through partnering arrangements. We won't focus on that particular change in detail in this webinar because we're quite limited on time, but I suspect it will be particularly relevant for certain sectors of the market, such as technology and sciences, and perhaps less relevant for others. So now that we have a feel for the scope of the changes, let's start to take a look at the status of implementation in the UK. In terms of the current status of procurement reform in Scotland, there are 2 strands of reform in particular that we're going to look at today. The first is the implementation process for the EU directive itself, and the second strand is the implementation of the Procurement Reform Scotland Act 2014, which is a slightly different regime that sits alongside and complements its European counterpart. The Scottish Government has stated that it's seeking to implement a coordinated approach to implementation of both of these strands. The Scottish Government considers that although many elements of the EU directive will require a direct pass-through, some have greater flexibility, and in order to decide on a position on these areas, the Scottish Government issued a consultation on 9th of February 2015, which ran to 30th of April 2015. Consultations therefore now closed, and we await the results. It's difficult to take a view, therefore, at this stage on exactly what the Scottish implementing legislation will look like. In terms of the timeline for that implementation, the Scottish Government has stated it's looking to implement both the regulations implementing the new EU Procurement Directive and the Procurement Reform Scotland Act 2014 at the same time, which is likely to be towards the end of the year. In terms of the Procurement Reform Scotland Act 2014, this now has royal assent, but is still, as discussed previously, awaiting implementation. The Act applies to all public service contracts with a value in excess of £50,000 and all public works contracts with a value in excess of £2 million. It will therefore catch contracts below the threshold set out under the EU procurement regime, and it will partially therefore answer the question of what contracting authorities should do for below EU threshold contracts, but there will still be a gap for contracts for services and works below 50,000 and 2 million respectively. In terms of pulling out some of the key features of the Procurement Reform Scotland Act, I've set some of them out on the slide. For any contracting authority with a procurement spend in excess of 5 million, there will be a requirement to publish a procurement strategy. That strategy will need to be published at least on the internet and must demonstrate transparency and how payment timescales will be met from the top to the bottom of the supply chain. Frankly, this is likely to be an additional administrative burden on the public sector. However, on the upside, it may assist public sector bodies in managing and prioritising what is often a very complex, competing set of priorities in any given financial year. From a private sector perspective, it could be a very useful tool, depending on exactly what's in it, as it would allow an entity to identify the full pipeline of projects across the market and target their efforts at those that they believe to be aligned to their business, rather than simply bidding for all opportunities due to the lack of a visible pipeline. Separately, the Act also requires a procurement report at the end of the year, which will create greater accountability for the public sector, and will again prove to be a useful tool for the private sector in terms of tracking what has and has not been progressed in terms of the procurement strategy for each year, and trying to ascertain whether certain contracts will be procured the following year. The Act also requires contracting authorities to provide feedback at all stages of a procurement, including PQQ stage. This will of course be helpful for the private sector, as it will allow them to react where they've failed to pass PQQ stage and seek to improve in advance of the next tender opportunity. Feedback information is always helpful in terms of improving, but it does also raise the question over whether additional feedback will result in a higher level of challenge. In practice, many contracting authorities already provided feedback to bidders at PQQ stage, so this area of the Act may have less impact than originally anticipated. The Act will require that all contract notices are available in one place, which will be Public Contracts Scotland, and this is intended to produce an effective one-stop shop for public sector contracts in Scotland. This is definitely useful as it will bring together all contracts under one roof. However, I would flag that there's a different website in England and Wales for contracts caught by the English regulations, and therefore UK-wide bidders would need to check two different databases rather than just one. There's also now a requirement to incorporate community benefits provisions in all contracts with a value in excess of £4 million. To be honest, this is something that many public sector bodies already sought to have included in their contracts, so this one appears to simply codify existing practice rather than introducing something new. There are a few other interesting aspects of the Procurement Reform Scotland Act, however we won't explore more of them here as our time is obviously limited, and I'd like to move on now to briefly consider the current position in England and Wales. So in terms of where we are in England and Wales, central government has already implemented the legislation required in order to align the law with the new EU Procurement Directive. The Public Contract Regulations 2015 came into force broadly on the 26th of February 2015. However, there are some provisions throughout the Act which are not yet in force and have a later implementation date. Some of these include requirements to publish certain documents electronically. We are therefore already in the position that the new EU Procurement Directive has been implemented in England and Wales, but not in Scotland, which produces a two-tier system where different regimes apply in different parts of the UK. In terms of some of the more interesting aspects of the public contract regulations, I thought I'd draw out a few of these for consideration during the webinar. Regulation 24 sets out the conflict of interest provisions, and that provides that contracting authorities have to take measures to effectively prevent, identify and remedy conflicts of interest arising in the conduct of procurement procedures so as to avoid any distortion of competition and to ensure equal treatment of all economic operators. The regulations specify that a conflict of interest shall at least cover any situation where relevant staff members have directly or indirectly a financial, economic or other personal interest which might be perceived to compromise their impartiality and independence in the context of the procurement procedure. This means each contracting authority will need to have considered and put in place appropriate measures. What this will look like may differ depending on the authority in question. However, I suspect we may see much more conflict of interest declarations being required from an authority's evaluation team. 2015 regulations now provide for the new competitive procedure with negotiation. This is set out at Regulation 29, and this new procedure allows a contracting authority to call for tenders and then negotiate those tenders and any subsequent tenders up to final tender submission in order to try to improve them. Minimum requirements and award criteria can't be negotiated, but the regulations suggest that other than these elements, the authority can negotiate, provided that they ensure equal treatment of all bidders. Competitive procedures with negotiation may take place in successive stages, and the number of candidates invited to negotiate must be at least 3. Regulation 58 includes the ability to take into account past performance, which we spoke about previously, as well as the turnover cap of 2 times contract value. As I mentioned at the outset of the webinar, the turnover cap is likely to be of real interest to SMEs who often previously considered that excessive turnover requirements were prohibitively high. Regulation 59 introduces the concept of the European Single Procurement Document, and that obliges contracting authorities to accept the ESPD, which consists of an updated self-declaration confirming that the relevant economic operator doesn't fall foul of mandatory exclusions in Regulation 57, meets the relevant selection criteria that have been set out under Regulation 58, and fulfills objective rules and criteria that have been set out under Regulation 65. Eventually, the ESPC will be provided exclusively in electronic form. However, at the moment, that's one of the provisions that aren't yet in force, and a contracting authority is entitled at any time to request that bidders send on the supporting documentation and can ask bidders to supplement or clarify the relevant certificates. There are other interesting aspects of the new regulations. However, we only have a limited amount of time, and we wanted to highlight a recent case which has left a fairly big footprint in terms of the procurement regulations as they stand, and I'm therefore going to hand you back to Kate now to summarise that case.
Thanks, Ewan. One of the most interesting cases we've seen recently relating to public procurement is the Fastweb case, which has had an impact on the public sector in particular in terms of mitigating the risk of ineffectiveness orders. As many of you know, following the introduction of the Remedies Directive back in 2009, the remedy of ineffectiveness orders was introduced. This allows the court, where specific grounds are satisfied, to award an ineffectiveness order which results in the entire contract effectively being set aside. One of the grounds for obtaining an ineffectiveness order is that the contracting authority has failed to publish a contract notice, also referred to as an OJU notice, advertising the contract. The regulations state that it was possible to mitigate this ground by publishing what is known as a voluntary ex-ante transparency notice, or a VEAT notice, and then observing a mandatory standstill period of 10 days. This was seen as an effective way of mitigating the risk of such a challenge until the Fastweb case. So Fastweb concerned the direct award of contract by the Italian Interior Ministry, Ministero dell'Interno, to Telecom Italia for the development of telecommunications services. The contract was awarded on the basis that Ministero dell'Interno considered the grounds for using the negotiated procedure without the prior publication of contract notice applied. They therefore published a VEAT notice and observed a 10-day mandatory standstill period before entering into the contract. Fastweb then challenged the direct award of the contract in the Italian courts. The Italian Administrative Court found that there had been a breach of the procurement rules and annulled the decision awarding the contract, declaring it ineffective. The case was then appealed to the Consiglio di Stato, who also found that the grounds for use of the negotiated procedure without prior publication of a contract notice did not apply, and there had therefore been a breach. However, the Consiglio di Stato referred the question of whether or not the contract could be declared ineffective, even though a VEAT notice had been published and the standstill period had been observed, to the European Court of Justice for consideration. The European Court of Justice considered the conditions for the issue of a valid VEAT notice, and in particular the question of the justification that must be set out in that VEAT notice and what the requirements are in order to rely on the exception in Article 2D4 of the directive, which applies where the contracting authority considers that the award of a contract is permissible without prior publication of contract notice, that it has published a VEAT notice and observed the 10-day standstill period. So the key principle coming out of the ECJ's judgment of the case is that in order to rely on this exception, all three conditions of Article 2D4 of the directive must have been fulfilled, i.e. the contracting authority must have considered that it was permissible to award the contract without prior publication of a contract notice, a VEAT has to have been published, and a 10-day standstill period has to have been observed. The interesting point is that procuring authorities need to have acted diligently in reviewing whether a contract is subject to the procurement rules and review by the relevant review body, which in the case of the UK is the National Court. And this includes the review of the justification which is stated within the VEAT notice. The review body would therefore be considering whether the contracting authority acted diligently and could legitimately hold that the conditions in the directive were satisfied. In the event following such review that the review body finds the relevant conditions are not met, then the contract must be declared ineffective. The effect of this is that the relevant review body has the ability to look behind the justification in the VEAT notice that has been published, and in the event that the review court does not find that the conditions for awarding the contract without prior publication of a contract notice apply, then it can render the contract ineffective. Clearly, the implications of the Fastweb case mean that any contracting authority must be very careful to ensure that there is proper justification for seeking to award a contract without prior publication of contract notice, and the justification must be clearly stated in the VEAT notice published in connection with that contract. It's no longer safe to assume that publication of a VEAT notice and then observing the required standstill period will fully mitigate the risk of an ineffectiveness order. I'll now hand you back to Ewan for a quick summary before we open the floor to questions.
Thanks, Kate. I thought it would be useful at the end of the webinar to draw together some of the points we've discussed. So at the moment we've got regulations in England and Wales which implement the new EU Procurement Directive. In Scotland, however, the Scottish Government consultation has concluded, but we do not yet have any draft regulations or a firm timeline for implementation in Scotland. Also, the introduction of the Procurement Reform Scotland Act means that an additional category of contracts will now be caught by the procurement regime, as the thresholds for that Act are well below the EU level thresholds. The Procurement Reform Scotland Act also introduces additional administrative burdens on the public sector, but those may in turn lead to more effective programming of a procurement pipeline, and from a private sector perspective, the ability to strategically target those contracts that you wish to tender for. Many of the reforms which are being progressed are intended to simplify procurement, such as the introduction of the SPD and shorter timescales in the regulations, and these are likely to be welcomed by both the public and the private sector. However, although the overall objective is to simplify procurement processes, we will have different regimes in different parts of the UK. This is likely to be realigned to some extent when the Scottish legislation for implementation of the new EU Procurement Directive comes into force. But there are likely to be small differences, and what this means in practice is that for those bidders that tender for contracts throughout the UK, they will need to be aware of and conform to the relevant law and processes in each jurisdiction. In addition, despite evolving regulation, public procurement is also an area of ever-expanding case law, and Kate's summary of the Fastweb case illustrates this. Although it applied to the old Procurement Directive, it's clear that the European courts will interpret these directives very strictly, and where a contracting authority considers that it can award a contract without first publishing a contract notice, then it is now even more important than ever to ensure that the reasons for doing so are legitimate and justifiable.
We've now come to the end of the presentation section. Hopefully that's been useful and interesting, but we do still have a few minutes left to answer any questions. If you haven't already done so, you can ask us a question by typing into the chat box. If we run out of time, we'll try and get back to you separately in relation to your question after the webinar. Just while you're doing that, I'll take the opportunity to remind you that this webinar and other webinars in the series will be recorded and will be available on our Vimeo site. So please do share the link with colleagues who may find this webinar useful. We'll be circulating details of the recording to participants after the webinar. We'd also really appreciate any feedback on both the format and content of the webinars so that we can continue to improve them and also to tailor them to ensure they are as relevant as possible for you. In addition, we'd be particularly happy to hear your thoughts on any other topics you would like to see covered in future webinars.
Okay.
In terms of questions, actually, it'd be helpful, if we could have a quick recap of the current thresholds.
Yep, so the thresholds are different for the EU procurement regime and then obviously the separate Procurement Reform Scotland Act. So under the main EU thresholds, the threshold for works contracts, £4,322,012, and for Schedule 1 entities for services contracts, it's £111,676 for services. For other public sector contracting authorities that aren't listed in Schedule 1, it's slightly higher at £172,514. So you can see there that the difference between the EU thresholds and the Procurement Reform Scotland Act is quite big, particularly in relation to works contracts, where you have one sitting at 2 million and the EU level sitting at over 4, and again on services with one sitting at 50,000 under the Procurement Reform Scotland Act, and over 100 for Schedule 1 entities and 172 for non-Schedule 1 entities. So the Procurement Reform Scotland Act does catch a lot of additional contracts that wouldn't previously have been caught.
Okay, thanks very much.
And there's another question here actually, which might be a good one for you to answer, Kate, which is what's the current landscape like in terms of the level of challenges?
I would say that we're typically seeing both public and private sector becoming much more sophisticated when it comes to procurement challenges. The public sector have really been developing their procurement processes, something that you mentioned during the webinar, Ewan, and they're obviously doing that to seek to mitigate the risks of the challenge. But on the other hand, we're also seeing private sector becoming much more aware of the procurement rules. For example, almost all bidders are now asking for full feedback information, and there's, I think, definitely a perception that there are more challenges being instigated now. So a bit of a trend in that direction. Well, I think that's the last of our questions and our time's up for today. I do hope you've enjoyed this webinar and found it informative and useful, and we look forward to welcoming you to future webinars. Thanks very much.